A warm welcome to the viewers of Legal Talks. Today, Advocate Dr. M. Sathya Kumar is with us. Welcome, sir.
Good evening, ma'am.
Whether the Revenue Department is required to defreeze the bank account once the required amount for filing has been deposited by the appellant.
If you see, Ram, the question is very much relevant. When the accounts are frozen by the GST department and the remedy that is available for them. It was the same question of law that was raised before the Madras High Court in the case of J-Tech Molds, Dice versus Deputy Commissioner GST. The WP number is 33523 of 2023, dated November 30, 2023. So generally, as per section 107 of the CGST Act 2017, the section 107 provides that the taxpayer or the department may appeal against any decision or order passed by an adjudicating authority under the GST. Under this Act or the State Goods and Service Tax Act or Union Territory Goods and Service Tax Act within 3 months. The timeline here is very clear. Within 3 months or 6 months respectively. The section provides for if you are going for the appeal within the duration of time limit provided under this section, that is 107 of the CGST Act 2017, the section says that pre-deposit of 10% for admittance of appeal filed by the taxpayer and grant of automatic stay on the remaining amount within 3 months or 6 months as the case may be, you can file an appeal. And while you are filing an appeal, you need to make a pre-deposit of 10%. And this 10% amount, the appellate authority shall pass such order as it thinks just and proper, confirming, modifying or annulling the decision or order appealed against. An order of enhancing any fee or penalty shall not be passed unless the appellant has been given an opportunity of showing cause against that order. So the question here is, if the appellant has made a pre-deposit of 10%, as per section 107 of the Central Goods and Service Tax Act 2017, whether as the stay is granted, whether the account has to be defreezed. It came up before the Madras High Court in the case of, as I said, J-Tech Mold Dice versus Deputy Commissioner GST. It was noted that as per section 107 of the CGST, if the petitioner has paid 10% of tax dues along with penalty for filing appeal, the respondent proceeding would automatically be stayed as said in section 107. So here in this case, it was opined that the petitioner had paid a sum of rupees 83,000 in this case. The respondent is supposed to, the department is supposed to defreeze the bank account of the petitioner as per section 107
of the CGST
Act 2017. It was directed under this writ petition, the court directed that the respondent is the department.
GST department.
The respondent is required to take into consideration the representation filed by the petitioner and defreeze the petitioner's bank account after submission of proof of deposit. This was the direction given by the Madras High Court under the WP number 33523 of 2023. It is a very important observation provided by the Madras High Court, because section 107 talks about pre-deposit. Section 107 talks about stay of proceedings. But it does not talk about defreezing the bank account. So when the section 107 of the CGST Act 2007 is silent, then there was a question of law whether accounts that were frozen due because of the order passed by the adjudicating authority, which is appealed against, if the pre-deposit of 10% is done by the appellant, whether account has to be defreezed or not. So the Madras High Court has directed, according to the law now, is that if you are making 10% of the pre-deposit of the amount along with the penalty for filing, then the account has to be defreezed mandatorily because of this direction provided by the Madras High Court. And accordingly, the law is now settled to an extent where once you make an appeal by paying the pre-deposit, the defreezing of bank account will happen. And this is the precedent, law of precedent as of now, Ram.
Thank you for your valuable time, sir.
Thank you, Ram.